Assalamualaikum. My name is Shahirah Binti Ahmad Fadrizah. In this video, I will present about crime of aggression. For introduction, according to customary international law, aggression is viewed as a crime, although there is no universally accepted definition and no international court or tribunal that can try perpetrators. A crime of aggression, often known as a crime against peace, is the planning, initiation, or execution of a large-scale and grave act of aggression utilizing government's armed group. The Rome Statute offers a comprehensive range of acts of aggression, which also can result in individual criminal liability, including invasion, military occupation, annexation using violence, bombing, and military blockade of ports. Aggression is typically a crime of leadership that can only be committed by those who have the authority to create a state's aggressive policy, as opposed to the individuals who carry it out. If we examine the German invasion of the Soviet Union during World War II, Soviet jurists Aaron Training introduced the first successful proposal to outlaw aggression. The Charter of the International Military Tribunal stipulated criminal accountability for initiating aggressive war, which became the central issue at Nuremberg. Since the 1940s, no individual have been convicted for aggressive behavior. The existence of the crime of aggression in international customary law is widely acknowledged. In 2010, at the Kampala Review Conference, the countries member to the International Criminal Court adopted the criteria and requirements for exercising criminalized aggression, and it can be tried under international crimes. The picture in slide illustrates the condition of Stalingrad due to the invasion. Next is background during World War I and interwar. After World War I, the United Kingdom and France considered prosecuting Kaiser Wilhelm II for aggression. In a speech delivered on 11 November 1918, the British Prime Minister, David Lloyd George, called the loss of millions of the best young men in Europe and the violation of international law entailed in entering the territory of an independent country without its consent, as crimes for which an individual must be held accountable. The proposed prosecution was rejected by the United States due to opposition from the judges. Next, during World War II, the invention of the World War II prompted a rethinking of aggressiveness. The governments in exile represented in the London International Assembly advocated for the establishment of a formal international tribunal with jurisdiction over acts of aggression. At this time, the Soviet Union still viewed it susceptible to global assault, which motivated its desire to criminalize aggression. At the London meeting of 1945, the victorious Allies decided to criminalize aggression and prosecute their defeated foes, despite questions raised at the conference on whether war of aggression were prohibited under customary law. Both the Soviet Union, which invaded the Baltic states and Poland in accordance with the secret protocols of the German-Soviet Pact, and Western nations that planned an invasion of Norway were aware that they too could be accused of aggression. So they restricted the definition of crimes against peace to the action of their defeated enemies during World War II. law, the vast majority of prosecution for crimes against humanity occurred between November 1945 and November 1948. In some cases, such as Romania, they continue until 1949, and no individual has been punished for aggression before or after this time. First, because the court had to establish the illegality of acts of hostility. Second, they had to link such acts to specific individuals. For war responsibility trials in Finland, the Soviet Union invaded Finland in 1939, resulting in an unfavorable peace settlement in 1940. And in 1941, Finland attacked the Soviet Union, retaking the area that had been given and invading part of the Soviet Union that had never been a part of Finland. In 1944, the tide of battle shifted against Finland, and the country signed an armistice with even less favorable conditions. The ceasefire required Finnish participation in prosecuting those accused of war crimes. Hence, the Allied Control Commission in Finland insists on conducting aggressive trials during the Second World War. The law creating the tribunal imposed criminal liability on those who substantially helped to Finland's entry into the war or obstructed peace between 1941 and 1944. In contrast to other definitions of crimes against peace, the Finnish trials prosecuted people who joined the government after 1941 and refused Soviet peace offers. Initially, 7 defendants were convicted, but the ambassador was acquitted. However, the verdict was changed to punish all defendants with heavier penalties, including up to 10 years of imprisonment with hard labor. The prisoners were treated leniently in prison, and by 1949, they were all released. Next is Rome Statute. The Rome Statute, as amended at the 2010 Kampala Review Conference, defines aggression as the planning, preparation, initiation, or execution by a person who is able to exercise absolute control over or guide the political or military action of a state, of an act of aggression which by its character, gravity, and scale that represent a manifest violation of the United Nations Charter. The criminal prosecution of aggression is restricted to the most egregious act of state aggression. Non-state violence, which is an even more contested notion, is omitted. The Rome Statute further restricts the crimes of aggression to state leaders with policy-making authority, bearing even high-ranking officials or generals who wage an aggressive war. Moving on to the jurisdiction, the International Criminal Court could only punish an act of aggression if the aggressor state exerts its jurisdiction over the crime of aggression or if the Security Council refers the case to the ICC. Some critics say that the International Criminal Court should not prosecute aggression. One frequent complaint is that justifiable war is a political decision, and the involvement of a court in such a case could undermine its legitimacy. Due to the limited scope of the crime and the court limited authority, prosecution by the ICC is doubtful. The International Court jurisdiction over aggression was activated on July 17, 2018, following a vote by 2/3 of state parties as of 7 March 17 March 2022, 43 states have accepted or acceded to the Rome Statute revision on the crime of aggression. Next is customary law. Scholars of international criminal law agree that the crime of aggression is codified in international customary law, but they disagree on the precise nature of violence that falls under this rubric. This bar is certainly set high to differentiate criminal aggressiveness from other forms of aggression. According to Antonio Case, planning or organizing or gearing up or involved in the initial use of military group by a country against the national sovereignty and political independence of another state in contravention of the UN Charter, provided the acts of aggression concerned have large-scale and serious consequences, are all considered aggressive acts. For an act to be considered aggressive, both mens rea and actors must be present. According to Israel lawyer Yoram Listin, aggression can only be committed by a small number of high state officials who make the decision to fight aggressive war, as well as any followers who know their plan will be utilized to wage aggressive war. However, other legal scholars insist on a more specific goal, namely that of trying to get territory expansion, to gain financial benefits, or to intervene with the internal affairs of the aggressor state. Next is self-defense. Self-defense is also firmly entrenched under international law. Article 51 of the UN Charter qualifies the prohibition on the use of force in Article 2 of the UN Charter for a state that has suffered an armed attack is therefore permitted to employ force in self-defense until the United Nations Security Council intervenes. Certain states have controversially maintained at various times that the fundamental right to self-defense include the right to preemptive self-defense. Prior to the First World War, a number of states maintained the right to employ war for defense objective. This right to wage war for defensive purpose was not limited to situations in which a state or one of its allies had been attacked on its territory. The right to use war for defensive purposes extended to situations in which an unfair threat of impending military group was aimed against a particular territory or the territory of one of its allies. However, the UN Charter modified governments' perception or conceptions of the right to self-defense. UN Charter Article 2, 4 and 15.1 limit the right to self-defense to situations involving an armed attack. A good way to illustrate this issue is by employing the facts of the attack on Pearl Harbor. On December 7, 1941, Japan launched a surprise attack on the United States Pearl Harbor naval base in Hawaii. The Japanese military planned the attack in Tokyo throughout 1941. On November 26, 1941, 6 Japanese aircraft carriers departed from Kuril Island and began their voyage to a position northwest of Hawaii, where they arrived in early December 1941. Then in the early morning of December 7, 1941, The aircraft carriers launched their aircraft, which flew to Pearl Harbor and physically attacked the naval base. The US was unaware that the Japanese attack was inbound. However, if the US were aware of the incoming Japanese attack, at what point along the operations timeline could the US have lawfully used force in self-defense under international law current framework? Unfortunately, official decisions related to aggression and preemptory self-defense are scarce and offer little assistance in answering this question. For the conclusion, in light of the foregoing, the exclusive focus of the current definition of the crime of aggression not only hinders the ability of the International Criminal Court to achieve its goal of preventing the commissions of crimes and promoting peace, but also impedes the ability of the state parties to prevent suffering caused by armed conflicts. That's all from me. Thank you.